Thank you, my Lord Chief Justice. What is the effect of the Election Laws Amendment Act 2017 on the conduct of the presidential election held on the 26th of October 2017? And two, is Section 83 of the Elections Act as amended unconstitutional? The second and third petitioners plead in paragraph 74 and 75 of their petition inter alia that the Election Laws Amendment Bill 2017 was intended to diminish the role of technology in elections, open election results to manipulation, and signal to voters that it would not be possible to successfully challenge the results of the fresh presidential election, even if the same were to be unconstitutional, unlawful, or irregular. They state that the said bill has since become law with the overt approval of the third respondent and has been gazetted as Election Laws Amendment Act number 34 of 2017. Consequent upon that pleading, the petitioners raise for determination by this court at paragraph 140 of their petition the issue that in light of the amendment of Section 83 of the Election Act by the Election Laws Amendment Act 2017, after the conduct of the fresh election, the question would be, which law is applicable for purposes of determining the present dispute, and two, whether Section 83 of the Elections Act as amended is unconstitutional and invalid. The petitioners then seek various reliefs, the one relevant to the above pleading being that a declaration be made that Section 83 of the Elections Act as amended is unconstitutional and invalid to the extent of its inconsistency with the Constitution. As regards the issue of the applicable law in respect of the 26th of October 2017 election, our view is that as at the time the cause of action arose, to wit, the 26th of October 2017, the law then applying was the Elections Act 2011. The amendment laws did not become effective until the 2nd November 2017. In that context, therefore, the common practice is that legislation should be effected prospectively and not retrospectively. That is to say, laws should be forward-looking and should not apply backwards in time. Prospective application of legislation is based on ancient Roman and English law, and we've given you a quotation there. We've also quoted some American case where the court said, as I quote, the principle that the legal effect of conduct should ordinarily be assessed under the law that existed when the conduct took place has timeless and universal human appeal. It is a conventional rule of construction that legislation must be addressed to the future, and a statute should not be given retrospective operation interfering with antecedent rights. We are inclined to the standpoint that legislation should bear only prospective effect in the absence of special legislation signal to the contrary. Where a legislative body thus wishes to change the law regarding a past event or action, its intent is to be clear enough. By this principle, where legislation is ambiguous or silent as to its effective date, it should be presumed to be prospective. In the present instance, when Parliament passed the amendment to Section 83, it did not state that the law shall apply retroactively. The United States Supreme Court in Landgraf made this presumption to statutes altering substantive rights. That court presumed prospectivity to avoid construing a new law that otherwise might have attached new legal consequences to events already completed before the law enacted. Although the Landcraft case dealt with private actions, the reasoning is, in our view, germane to the instant matter. This court has furthermore already pronounced itself on the retrospectivity of laws in the case of Samuel Kamau Macharia and KCB at paragraph 61, which we have reproduced. The issue in this petition, however, is that the amended law was not made retroactive by Parliament and should therefore be read prospectively. It is noteworthy that in addressing the same issue in Moses Masika Wetangula and Muskari Kombo, the Court of Appeal adopted the dicta in Morgan and Simpson and took the position that an election must be guided by the law as it was on the date of the election. And we have reproduced what the Court of Appeal said. From the foregoing, we find that the applicable election law in respect of the conduct of the 26th of October 2017 election was the Elections Act 2011. The Election Laws Amendment Act 2017, Act 34 of 2017, not having come into effect as at the time of that election, and the same not having had retrospective application. The second issue is this. The second and third petitioners seek a declaration that Section 83 of the amended law is unconstitutional and invalid. Having taken into account all the submissions on the matter and being aware as we are that the amended law is the subject of various pending causes before the High Court, such as in the petition number 548 of 2017, the Katiba Institute Africa Center for Open Governance and the Attorney General. We restate our stand in similar circumstances as we did in the matter of the Interim Independent Electoral Commission, where we stated at paragraph 47 of that judgment, and we have reproduced paragraph 47. However, the above position can be distinguished, as we have stated elsewhere in this judgment, from a matter arising in the course of a presidential election in regard to which the Supreme Court has unqualified jurisdiction and where the issue essentially relates to a petition before the court. The Supreme Court, in its advisory opinion in the gender representation matter, advisory opinion number 2 of 2012, stated that its jurisdiction to adjudicate on any dispute touching on the presidential petitions, while acknowledging the mandate of the High Court on determining the constitutionality of a statute, at paragraph 76 of advisory opinion number 2 of 2012, which again we have reproduced overleaf. The overlapping jurisdiction between the High Court and the Supreme Court only arises where interpreting or applying the provision insofar as it relates to the presidential petition. Where, however, the challenge to a statutory provision is directed as a ground in the context of a presidential petition, the Supreme Court should not find any difficulty in addressing the same in the context of a presidential petition. This does not include the power to this does not exclude the power to refer the matter to the High Court for its proper disposal depending on the circumstances of each case. We find no reason, therefore, to disturb our already settled principle of not taking away the jurisdiction of other superior courts and determining issues pending thereat. We thus would restate our position in RILA 2017 at paragraph 313, where we stated as follows: having that in mind and fortified by our observation that the interpretation of Section 14 of the Election Offences Act is a live matter at the High Court, we are unable to address our minds to any allegation that touches on this section. That is the end of the matter. Similarly, we leave the issue of the unconstitutionality or otherwise, or invalidity of Section 83 of the amended law to the determination of the High Court, where the matter is currently under consideration. In stating so, we see no prospects of the High Court making a finding that would affect our determination of the present presidential election petition. Thank you, Chief Justice.
Thank you, DCJ. We have in this matter a concurring opinion by our sister, Justice Njoki. I would like to call upon her now to read her concurring opinion. Justice Njoki.
Thank you, CJ. My concurring opinion is on the single issue on the applicability and constitutionality of Section 83 of the Elections Act as amended. Although the parties referred to numerous decisions of this court on matters deserving the exercise of the court's jurisdiction, none linked their arguments to the role of this court on questions touching on the interpretation and application of the Constitution from the perspective of this court's exercise of exclusive original jurisdiction. More specifically, whether an issue touching on the constitutionality of any law integral to the determination of a cause before us, although pending before another court, falls to this court's determination. Section 83 of the Elections Act 2011 was an integral part of this court's consideration of the validity of the 8th August 2017 presidential election. The decision of the majority turned on the disjunctive interpretation and application of this section to the conduct of the election. At paragraph 171, the court, in majority, noted that Section 83 was indeed the fulcrum of the petition. Paragraph 187 of the majority opinion set the stage for the interpretation of this section, and at paragraph 211, the court laid out the application of Section 83 by the courts as follows, quote, "In our respectful view, the two limbs of Section 83 of the Elections Act should be applied disjunctively. In the circumstances, a petitioner who is able to satisfactorily prove either of the limbs of the section can void an election. In other words, a petitioner who is able to prove the conduct of the election in question substantially violated the principles laid down in our Constitution, as well as other written law on elections, will, on that ground alone, void the election. He will also be able to void an election if he is able to prove that although the election was conducted substantially in accordance with the principles laid down in our Constitution, as in other laws on elections, it was fraught with irregularities or illegalities that affected the result of the election. While the cases cited by counsel in this case revolved around this court's appellate mandate, the Supreme Court's jurisdiction as an election court and the interplay of the Constitution and the law to the issues at hand can be summarized from the reasoning in the Supreme Court, this court's case of Aramat and Lempaka and others, in which, at paragraph 102, we said, the Supreme Court's jurisdiction in relation to electoral disputes is, in our opinion, broader than that of other superior courts. We note in this regard, while the Court of Appeal's jurisdiction is based on Section 85A, that of the Supreme Court is broader from Article 163 of the Constitution. This interpretation and the language of the Elections Act and the Election Laws Amendment Act places Section 83 at the center of any determination by an election court. After the hearing and analysis of the case from submissions and evaluation of the evidence, the application of Section 83 serves as the judge's determinate fact vector. Therefore, although the parties seem to be in agreement that the constitutionality of that section was removed from this court's exclusive original jurisdiction and was the preserve of the High Court on the basis of pending suit, my opinion is that this court's determination of that issue is necessary to complete the mandate bestowed to us under Article 163. As rightly urged, this court has time and again held that issues pending before another court will not be subject to determination before the Supreme Court, but rather this court shall allow the other court to have the jurisdiction to determine the court in the first instance. However, in all those instances, this court had in mind ordinary causes coming before it by dint of Articles 163(4) A or B, that is, appeals from the Court of Appeal, and issues of constitutional interpretation or application, which must have formed an integral part of the issues raised in the superior courts and been a matter determined by them. It follows, therefore, that this court will exercise deference to another superior court below it in its hierarchy in instances in which the court of original jurisdiction in respect of the matter before it is that superior court. The question, however, is whether the Supreme Court, in hearing a matter in which it has original jurisdiction, will determine an issue of interpretation or application of the Constitution, or whether it will defer the issue to the courts below it. My opinion is that where the court is exercising original jurisdiction, it's imperative for the court to answer, in the first instance, such questions. Since the determination of a petition challenging the declaration of a presidential election falls to this court, the legal implication of leaving main issues unresolved is the creation of a lacuna in the application of the law. Losing the chance to clarify it until the jurisdiction of the Supreme Court will be invoked in another like matter, or such time as the legislature eliminates the penumbrous occasion therein. The grave occasion of this court's acceptance of the submissions of counsel to skip the central determination revolving around the constitutionality of Section 83 as amended leaves a matter properly before this court unresolved. The Constitution does not countenance a situation whereby this court makes a partial determination on any matter, especially in an election cause. This court is enjoined to determine with finality matters before it, and the resolution of the presidential petition under Article 140 is one of them. Failure by this court to determine that issue will leave part of the dispute between the parties unresolved. In terms of Section 83, it would have the effect of leaving undetermined the fulcrum of the election cause itself. Consequently, the resultant decision would be one falling short of the explicit commands of Article 140 and Article 159 that justice shall not be delayed and the purposes and principles of the Constitution shall be protected and promoted. Such an incomplete decision would also be contrary to the distinct objects of the court which are set out in the Supreme Court Act. In context, the petitioners invited the court to determine the following issues inter alia. Quote, in light of the amendment of Section 83 of the Elections Act by the Election Laws Amendment Act 2017, after the conduct of the fresh election, which law is applicable for purposes of determining the present dispute, and whether Section 83 of the Elections Act as amended is unconstitutional and invalid. In consequence, the petitioners sought a declaration that Section 83 of the Elections Act as amended is unconstitutional and invalid to the extent of its inconsistency with the Constitution of Kenya. In response, the first and third respondent urged that Section 83 of the Elections Act 2011 was amended after the election. The subject of the petition herein having been conducted. Consequently, they argued that Section 83 is not law that is applicable to the determination of the election petition herein. As elaborated earlier, the issue of the constitutionality of Section 83 is integral to the determination of the present petition. As preferred earlier, this court is enjoined to resolve disputes between parties with finality. Therefore, in order for this court to determine with finality the question of validity of the declaration of the president-elect, it must inevitably determine all issues. This court is charged to signal the law it has arrived on in arriving at its determination in any matter, more importantly, in determining the validity of a declaration in a presidential election, and for good reason. Firstly, it attracts enormous public interest. Secondly, other courts look to this court to offer a guiding compass on interpretation and application of the Constitution and its interplay with applicable laws. And thirdly, for certainty and predictability of Kenya's electoral jurisprudence. I emphasized on the right-centric nature of election petitions and the pivotal nature of precedent-setting decisions of this court in Raila Odinga 2017, where I did say, quote, "It is proper to emphasize that the Supreme Court, in discharging its mandate as an election court, remains the precedent-setting forum in the country, and its decisions must be carefully analyzed to ensure that a jurisprudential crisis or confusion does not ensue. Were that to happen, the court would have failed the Constitution and the people," end quote. I agree with the submissions made by Mr. Ogeto for the third respondent to the extent that the doctrine of presumption of constitutionality would be applicable in respect to Section 83, as long as the provision has not been adjudged unconstitutional by any court. However, there is pressing need for this court to conclusively determine the present petition together with all issues, and therefore the two key issues, that is, whether Section 83 of the Elections Act is the applicable law and whether it is inconsistent with the Constitution, must be addressed. I will briefly address the two. Whether Section 83 is the applicable law. The Elections Amendment Act 2017 was passed by Parliament on the 12th of October 2017, submitted to the President for assent on the 13th of October. The Constitution provides that the President must assent to the bill or return it to Parliament within 14 days. If he does not, the bill is deemed to have been assented to at the end of the period. The President did not assent to the subject bill, and by operation, it was deemed assented on the 27th of October. It was then published in the Kenya Gazette on the 2nd of November. Since the Act provides that the law comes into force on publication in the Gazette, it came into force on the 2nd of November 2017. It was the submission of counsel for the petitioners, the first and second respondents, the Honorable Attorney General, and counsel for the first interested party that the amendment law was inapplicable to the present petition. However, counsels did not consider the import of Section 83 in isolation from other sections of the Election Laws Amendment Act, or to distinguish its application from those sections. Section 83 of the Elections Act appears in Part 7 of the Elections Act under the heading Election Petitions. More specifically, it addresses the conduct of the court after an election petition has been filed before it. In this instance, the determining cause triggering the application of the law is the cause presented for the court's determination. Section 83 contains the test to be applied by a court while determining an electoral cause before it. Therefore, it does not follow an electoral event like the election. It follows the declaration by a judicial officer on an election cause. In my interpretation, Section 83, as amended, is therefore the applicable law, not just in this petition, but in other election petitions and appeals pending before other courts. The second question is whether Section 83, as amended, is unconstitutional or invalid. The petitioners imputed the constitutionality of the amended Section 83 of the Elections Act as against Articles 81 and 86. Their argument is that its disjunctive application would violate the principles of the two provisions. In addition, they generalized their claim of unconstitutionality to 4 constitutional imperatives. 1, the independence of the judiciary. 2, the right to public participation. 3, the right to universal suffrage. And 4, the constitutionality and other statutory duties of the Commission. The challenge therefore goes to, quote, the legislative intent in enacting the legislation and the textual violation of certain rights and obligations mandated under the Constitution and principles of the electoral system. These aspects provide sufficient grounds because the issue of unconstitutionality was pleaded and canvassed to sustain a claim for determination before this court. Any challenge of constitutionality or otherwise ought to be brought on the basis of inconsistency with the Constitution as directed by Article 2.4 of the Constitution. The role of a judge is to compare the impugned law or action with the provisions of the Constitution to determine consistency or otherwise with the Constitution. There must be more than an implied or incomplete argument touching on the constitutionality to exhaustively determine a claim of inconsistency with the Constitution. Inconsistency on the basis of statute and on the basis of conduct are distinguishable and ought to be comprehensively pleaded. The petitioners challenged the amendment laws on the basis of invalidity of the law and legislative conduct of Parliament. The argument was that the purpose and effect of the law was at variance with Article 81 and 86 of the Constitution, and that the conduct of Parliament in enacting amendment laws stifled or overlooked the voices of critical actors in Kenya, compromising national consensus. I must say at this stage that it is not enough to plead inconsistency of a law with the Constitution as a tangential issue in a case. Claims of inconsistency must be well pleaded and argued, and where the court determines that such a critical question was given peripheral treatment, it may exercise its discretionary powers to ask the parties to delve deeper. The consideration of any law or the conduct against the Constitution is central to any legal proceedings. In the present case, the general position of the parties, faulty in my opinion, was that the issue of constitutionality of Section 83 as amended was removed from this court's jurisdiction due to a pending suit before the High Court. A perusal of the matter pending before the High Court revealed a claim made in respect to Section 83, in which that petition says, Section 9 of the Elections Law Act is unconstitutional because it creates a statutory threshold of invalidation of an election that is more onerous than what is contemplated in Articles 81 and 86 of the Constitution. It is a backdoor amendment to Articles 81 and 86 and an unjustifiable variation to the jurisprudence of the Supreme Court on Section 83 in Raila Odinga 2017. It also seeks to validate minority over majority holding over the issue. A principle developed in deference to the separation of powers, and more specifically in the light of the role of Parliament under Article 94 of the Constitution, is presumption of constitutionality. Any legislative action by Parliament is presumed constitutional, and the burden is on the person challenging the legislative act to show what manner it breaches the Constitution. This principle has been resounded in numerous decisions of the High Court, including Mugambi, Imanyara, and another, and the Attorney General. It is not apparent, either from this case by the petitioners by way of rebuttal of the presumption of constitutionality, or following the application of the law, that the same violates the Constitution, and more specifically, fundamental rights and freedoms. As such, the constitutional qualification against the presumption, in strict terms of Article 24 of the Constitution, does not arise. I must, however, add that the finality of the Supreme Court as a judicial agency and its role as the custodian of the Constitution militate, save for rare instances, dictated by circumstances of each case, against the blanket presumption of constitutionality without delving into holistic interpretation of the constitutional vis-à-vis impugned law or conduct. The judiciary is in general, and the Supreme Court in particular, retains control over the interpretation of the Constitution. The petitioners claim that the amendment compromises the independence of the judiciary and was an attempt to review this court's determination in Raila Odinga 2017. The legislative authority of the Republic is vested in Parliament. Parliament is the only body with powers to make provision, having the force of law, unless otherwise provided by the Constitution or legislation. Therefore, at the onset, by enacting the Election Laws Amendment Act, Parliament was well within its constitutional mandate. It was also urged that the legislative process was hasty, devoid of public participation, and ignorant of the views of other important stakeholders. It is admitted that on the 2nd to 5th October, the Joint Select Committee of the National Assembly and Senate Committees on Election Laws put in place avenues for public participation from different stakeholders through the submission of proposals. This fulfilled the requirements of public participation under Article 118. Was the amendment to Section 83 of the Elections Act meant to undermine the independence of the judiciary? The purpose of the Elections Act Amendment Law was elaborated by Honorable Cheptumo while moving the Election Laws Amendment Bill, reading for a second time in the National Assembly. And I quote from the Hansard of the 12th Parliament of the 10th of October 2010. I'll not read all of it, but just read excerpts. Honorable Cheptumo speaking. Thank you, Honorable Speaker. I beg to move that the Elections Law Amendment Bill be read a second time. The bill I have sponsored also seeks to align the Elections Act with 3 decisions I have referred to, and in effect align the Act with relevant provisions of the Constitution. Close reading of election-related laws reveals that where there are gaps in the law, and indeed many and variant interpretations depending on the number of lawyers interpreting them. This is a highly litigant country where every Kenyan lawyer will have different interpretations of various situations and laws. Therefore, the bill proposes specific amendments to fill existing gaps in our scheme of laws and may lead to a legal and constitutional crisis if not addressed prior to the conduct of fresh elections. I wish to inform the nation that we receive views from all sectors of our society, and that Kenyans took advantage of public participation to come forward and give their input. Honorable Speaker, allow me to move to the specific clauses of the bill. Clause 9 of the bill seeks to amend Section 83 of the Elections Act. This section was the focus of the presidential election. What we are saying here is that Section 83 has 2 aspects. One, in an election petition, it is the business of the petitioner to establish one aspect of that section. The second aspect is about showing the non-compliance with the Constitution and indeed substantially affected the results. The problem with the ambiguous laws is that they are subject to interpretation by different people. We want the law to be clear. In our region, the same provision as proposed in the amendment bill is in use in Nigeria, Ghana, Zambia, Tanzania, and Uganda. I cannot explain how we did not provide for our laws to be realigned in that manner. What is relevant now is for this House to make a decision and to amend our laws. End quote of the Hansard. The Constitution organizes the functioning of the state in 3 distinct arms of government: the legislature, the executive, and the judiciary. Each of these entities has powers meant to protect the Constitution and sovereignty of the Kenyan people. It does not, however, follow that when one arm exercises its authority, that authority automatically undermines the functioning of the other. In this case, Parliament did make reference to the court's interpretation of Section 83 in both the majority and dissenting opinions, and sought to clarify the law by legislation. The above provided as Hansard experts guide my consideration of the purpose and effect of the legislation. I am persuaded that Parliament was in no way invasive into the judicial realm in amending the impugned section. The purpose of the legislature was to clarify the law and to bring into conformity with international best practice. I hasten to add that a law does not become unconstitutional simply because it goes against the precedent of this court or other courts. This legislative mandate affords the opportunity for courts to reconsider precedent and nurtures the development of constitutional law. Finally, to the question, does the disjunctive approach of amended Section 83 violate the principles in Articles 81 and 86? Article 81 outlines the principles of the electoral system. Article 86, on the other hand, provides the imperatives of voting, voting method, counting, tallying, announcement, and post-election safeguards. These principles are therefore cross-cutting. A strict dichotomy, of which I am in favor, would separate these two principled provisions on the bearing of process and outcome. These two critical elements of an election are crucial in the determination of its validity. The process gives rise to the outcome. Therefore, deviation from the process must be considered against its effect to the declared outcome. In this court, in Peter Munya and others, emphasized that the Elections Act and regulations thereunder are normative derivatives of the principles embodied in Articles 81 and 86, and a court of law cannot disengage from the Constitution while interpreting them. Section 3, as amended, provides a formula for evaluating the conduct of an election against the process and outcome, and is the product of Article 82 of the Constitution. It does not take away the powers of an election court to determine the compliance of an election with the purpose and principles of the Constitution. As such, I find no persuasion in the claim that it is inconsistent with the Constitution. I conclude by saying the following. Section 83, as amended by Section 9 of the Election Laws Amendment Act, is the law applicable for the determination of this petition. Section 83 also provides the determining formula to this election court adjudicating the election cause, and as such, it also ought to be the applicable law in other pending election causes before lower courts. The question of consistency of Section 83 with the Constitution is distinctive to that of the other provisions of the same amendment laws. Section 83 does not follow the electoral event, as does the substratum of the other provisions. Section 83 follows the declaration by the judicial officer. I find no persuasion in the impugned provision, its purpose and effect, or the conduct of the legislature, and the issue therefore ought not to be retried by the High Court.
Thank you, Justice Njoki. It's now my turn